I'm here sui juris and propria persona. I reserve all rights. I, Jonathan Troy Faithfully Colin Schuster, comma beneficiary and sovereign, and here under fraud, menace, and duress. Fiduciary advocate.
Before we even get into today's hearing, buckle up, because what you're about to witness is not law, not logic, and definitely not reality. This is Jonathan Schuster, a repeat courtroom performer who subscribes to sovereign citizen ideology, a belief system built on misused legal terms, imaginary contracts, and the idea that simply saying the right magic words can make the justice system disappear. Spoiler alert, it can't. In this case, Schuster insists he's an American national, not subject to U.S. law, claims the court is operating in admiralty jurisdiction, and repeatedly accuses judges and prosecutors of fraud, all while standing in a criminal courtroom that very much has authority over him. Today, we're covering not one, but two hearings where his refusal to engage with reality turns routine court procedure into chaos. Watch closely how the judge maintains control, how patience slowly wears thin, and how legal misconceptions crash headfirst into actual law. Because this case isn't just about jurisdiction, it's about what happens when confidence meets consequence.
This is a Social Security Certificate Trust action, which you are now a real party and interest to. I'm here sui juris and propria persona. I've challenged the jurisdiction of this court, and I don't understand, so I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my Social Security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your Social Security number. So as far as I know, I don't know your Social Security number.
No, I'm saying is my Social Security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your Social Security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is a commercial court.
It's not commercial.
Now you're saying that my Social Security number is attached to these charges. And so, which means this is a Certificate Trust action, which you are a real party and interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you saying you're committing?
This right here is where sovereign citizen logic always collapses under its own weight. Schuster believes that mentioning a Social Security number magically transforms a criminal case into a commercial trust action. That is completely false. Courts routinely store identifying information. That does not create a contract, a trust, or a bond against a mythical entity. What he's doing is conflating administrative record-keeping with maritime law buzzwords he doesn't understand. Notice how the judge answers calmly and directly, while Schuster keeps reframing the answer to fit his script. This is a common tactic. If the response doesn't match the belief, just talk louder and repeat it until it does. But courts don't operate on vibes, they operate on statutes, jurisdiction, and precedent. And none of those change because someone declares themselves a beneficiary out loud. Clip 2. Here's the irony sovereign citizens never seem to grasp. By standing in court, responding to questions, and demanding rulings, Schuster is actively participating in the very jurisdiction he claims doesn't exist. The judge offers him three legally valid choices: appointed counsel, private counsel, or representing himself. There is no fourth option called verbal spellcasting. When he insists on going sui juris, instead of simply answering yes or no, he's not being clever, he's stalling. Courts are required to ensure a defendant knowingly waives their right to counsel, which is why the judge keeps pressing. This isn't harassment, it's due process. And Schuster's refusal to engage meaningfully is exactly what keeps the case moving forward instead of ending it. Clip 3. This is the moment where fantasy collides with authority. The judge explains, clearly and calmly, that failure to appear results in a bench warrant, not as a threat, but as a legal consequence. Schuster immediately reframes this as intimidation because sovereign ideology teaches that accountability equals coercion.
You cannot enter a plea for somebody. That is, practicing bench from the law.
Courts don't need your consent to issue orders. Jurisdiction comes from law, not agreement. His repeated attempts to force dismissal, with prejudice, show a fundamental misunderstanding. Judges don't grant motions simply because someone demands them loudly enough. And the more he interrupts, the more the record reflects non-compliance. This is exactly how people talk themselves into additional charges.
I'm saying that you are subject to the jurisdiction of this court.
This matter cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice because this is a commercial matter. I'm a non-U.S. citizen American national by way of American Samoa. I'm beneficiary. I'm here sui juris and propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me.
Okay, he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please do
Schuster?
not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or sophisticated trust action. And so I'm here sui juris and propria persona. You know what that means. And so we can prove.
Don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those
Nobody's
three?
going to represent me. I can present myself, as I said.
So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you I'm here sui juris and propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're going to have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Okay. Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's no
can't.
need to
We
move
can't.
this any further because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position because
it's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no
So
arguing.
I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court on July 1st.
That date doesn't work
Why doesn't it work for you?
because I'm a man. I have things.
When the judge orders him to leave or face custody, that's not abuse of power, that's courtroom control. Judges are responsible for maintaining order, and Schuster's refusal to stop talking, combined with threats of charging officers with assault, crosses a line. Sovereign citizens love claiming victimhood at this stage, but notice what actually happens. The judge gives warnings, options, and time. There's no rush to cuffs, only consequences for behavior. And despite Schuster declaring the case dismissed, the reality hits moments later. Nothing he said had any legal effect. Declaring victory doesn't make it real.
I've come here multiple times under duress with threats from your end, and I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're going to come back on July 1st at 9 a.m. If you don't come back on July 1st,
Are you
then
threatening me now?
I'm telling you there's going to be a bench warrant issued if you don't show
You're
up. So
threatening me now.
I'm giving you the choice of showing up
No,
or a
I'm
bench
giving
warrant
you the
issuing.
choice to finish this matter now or be responsible for your actions.
We'll set this for July 1st. I'm
Would you
going
like to be responsible for your actions and set this further? Because you can do that, or you can dismiss this matter with prejudice.
I'm not going to do that today. So July 1st, 9 a.m. back in this
Now you're threatening
courtroom.
me. Abigail, what's the reason for the threats, Abigail? You violated my rights enough.
We'll just hold Speedy for this
You
week, Ms.
violated my
Roberts.
rights enough This matter needs to be dismissed with prejudice,
We'll see you back on July 1st,
or else what? You're gonna threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail.
I am telling you
No,
your
I'm telling you,
options.
this matter needs to be dismissed with prejudice. Because you cannot prove jurisdiction. This is a
Signature here.
antitrust action.
Signature
You're
here,
trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss,
So-
I'm speaking with Abigail.
You're done.
No,
you're
you
done.
can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is over.
You don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more
Giving
so
you
than
a
you already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone because this matter is dismissed.
And here we go again, new hearing, same script? Schuster refuses to approach the microphone, claiming it would grant personal jurisdiction. That's not a thing. Jurisdiction is established by law, not furniture placement. The judge isn't trying to trap him, she's trying to create a record. Ironically, by refusing to be recorded, Schuster undermines his own arguments. Courts rely on records, not memory, and if something isn't preserved, it didn't happen. This is another recurring pattern. Sovereign citizens sabotage themselves while claiming procedural violations that only exist because of their own refusal to cooperate.
No,
Let's address. We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to, I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said, because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster,
I reserve all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel.
Appoint counsel to me
Well,
without my permission. He has no permission to be my counsel. I'm here sui juris, appropriate persona. I, Jonathan Troy Faifuleo Somalia Colin Schuster, am here under fraud, menace, and duress. I've made a special appearance to this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
well, right
Are you
now,
able to answer them?
I am not here to be interrogated by you. You are
Well, I
under the
just don't
jurisdiction
understand
of this.
what's going on here.
I think you understand and you choose not
I
to
do
take
not
in the information.
understand
Okay, well,
what's going on
Mr.
here.
Schuster,
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris appropriate persona. I'm here of my own right, in my proper person. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either, which
I
you
need
would,
to represent myself.
well, you would. Either you
I
have
don't.
counsel or you are acting pro
Represent
se.
myself. And so, like I have told you, I'm here sui juris appropriate persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction, or is this an admiralty maritime jurisdiction?
Either. So,
right.
Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record, I
If
reserve
you
all
would
my
like-
rights. If you
If
cannot,
you would like,
I will
if you,
step up so you can hear me better, and I will
none of
speak
it's being,
louder.
none of it's being
I will
preserved.
speak
until you-
louder so you can hear me, but I reserve all my rights. And I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So I just
Schuster,
want to make sure
Mr.
the
Schuster,
reporter can hear me.
you are making legal arguments. All right, you are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will
So-
begin again so that the recorder can
Not
hear me.
choosing to be silent, you're choosing to make a legal argument. So we need to have that on the record.
For the record, I reserve all rights.
You've made that,
I, Jonathan, Troy, Faifo, Leaso, Malia, Toa, Colin, Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary, Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it, and then
This is one of the most telling moments of the entire case. The judge explicitly states that Schuster's issue isn't intelligence, it's willful refusal to understand. That distinction matters. He's not confused, he's committed to misinformation. And the contradiction is glaring. He claims no contract exists while simultaneously benefiting from deferred prosecution, which requires agreement to court authority. You can't accept the benefits of jurisdiction and deny its existence at the same time. That's not legal strategy, that's denial. The court recognizes this, which is why the case doesn't derail into nonsense despite his attempts.
Your Honor, I may be challenging 1077 in this case.
I understand that the city's bringing up whether or not you're able to proceed in this matter. So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold. And the fact that I think it's not that you don't understand, I think it's you choose not to understand, and that you have someone giving you information that you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect
we cannot
that is
move
causing you
forward.
to not be able to
To
understand.
challenge my competency, because I have challenged the jurisdiction of this court,
We're
and you have not
We're
proved
not dealing
jurisdiction.
in social security or contracts
You
or
have to prove
maritime.
jurisdiction before we can move any further.
So that's just not how it works in this court, and
No,
I don't
that's
think you
how
have
it
the
works.
legal.
You must prove jurisdiction because I have challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Miss Jennifer, can you
I'm
prove
Judge Grant, so I'm going to
Jennifer,
have you,
can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding.
I do not understand the nature or
Well,
cause.
he doesn't have legal training, so that I think is.
That does not matter.
Well,
If I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove jurisdiction before we can move any further. You've already tried to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody, and we cannot move further.
At the end of the day, this case perfectly illustrates why sovereign citizen arguments fail every single time. Jurisdiction isn't something courts need to prove on demand, it exists by statute, geography, and law. Schuster's repeated motions to dismiss, accusations of fraud, and misuse of legal language don't expose corruption, they expose misinformation. The judge followed procedure, protected his rights, and moved the case forward despite constant obstruction. And that's the takeaway: courts don't bend to slogans, scripts, or shouted objections. Reality wins. If you found this case as shocking or frustrating, as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss what happens next.
So, Ms. McDonald, what I think would be the next steps, I don't know if Mr. Parent, have you been able to provide any assistance to him on a standby basis?
No, Your Honor, he doesn't want any assistance.
Okay.
So I'd ask to withdraw as a
So we could go through the colloquy, we can provide him with the form for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So, Ms. McDonald.
I don't have a problem setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the waiver of right to counsel.
Absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I understand
We have
that.
speedy trial at
It is the
August
burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter with prejudice. And I motion to dismiss this matter with prejudice.
Denied.
Based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table, away from council, so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you if you'd like.
We cannot move until jurisdiction has been proven.
Yeah, it should be
You have failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
Right. So, Mr. Schuster, did the court say that was end of August, or?
It was August 9th is speedy trial.
Okay. So,
And if you plan on having me back here, you're taking away from my ability to provide and work.